Hello, I am Jonathan Rosenfeld, and today I am joined by my good friend and colleague, Jerry Bekkerman. Jerry is an attorney in Chicago and a partner at Taxman Pollock Murray and Beckerman. And today we are going to be discussing Camp Lejeune. Camp Lejeune, for people who may not be aware, is a very large military facility in Jacksonville, North Carolina. It's about 246 square miles, and the facility has been used primarily by the Marines for training and for deployment for the better part of 50 years. Unfortunately, what we've sort of come to learn relatively recently is that there was a significant amount of water contamination at the facility, which has led to a lot of illnesses. So today I am honored to be talking with Jerry, who is, on top of being a tremendous attorney, he is very knowledgeable about Camp Lejeune. So Jerry, first off, thank you so much for taking some time out and joining me today.
You're welcome, John. Thanks for having me on board to discuss this important topic.
So let's get right to it. This is really there was really some groundbreaking legislation passed in the past couple weeks, and that was part of the Camp Lejeune Justice Act. And there's really never been a piece of legislation like this in the history. But if you can sort of give us a little bit of background and just sort of give us a little bit of a Cliff Note version of the Camp Lejeune Justice Act and why it's really such a piece of groundbreaking legislation.
Absolutely. Well, thanks for the introduction, John. Basically, what we have here with this Camp Lejeune Justice Act and the entire situation is very unique in the world of mass tort and class action and multi-district litigation law. That's kind of law nerd term for what we're dealing with here. Basically, we have a class action that arises from damages and exposures of toxic chemical contamination as a result of U.S. military activity. And it's one of the first times I can recall in probably the history of civil litigation that the U.S. government has has in fact admitted that what they were doing at this military base from a time period of somewhere around 1953 to 1987 was admittedly polluting the water with known toxins and chemicals, polluting the air and creating really hazardous living conditions unknowingly for members of the military, their families, and in fact anybody else that's entered, served, worked at this base for any duration of time, 30 days in total or more. The camp was established in 1942 in North Carolina, and its water system drew from a shallow aquifer, which became polluted as a result of the design. So in essence, the way that the base was designed, it drew from this shallow aquifer, and all the toxins, and think about all the contaminants of a military base and all the industrial military equipment that is processed there, all the chemicals used in what the government did at that base would seep and leak into the water that the members of the military and the Marines and anybody at the base, whether it's a general contractor doing some construction and their family or vendors, anyone there for 30 days or more, would be exposed to that every day that they would brush their teeth, that they would take a shower. Back then, not everybody had, fancy water bottles and Hinkley Schmidt and all those kind of water delivery services that didn't exist. So everybody drank tap water, used tap water, cooked with tap water, showered with tap water, etc. Now, what were these contaminants? So toxic water contaminants included trichloroethylene, PCE, it's called. It's perchloroethylene, PCE. This is basically stuff that leaks from batteries, okay? So think about melting batteries, toxins of that sort leaking into the water supply. There's also air contaminants, including benzene from fuel, vinyl chloride vapors, smoke from burn pits, and other volatile compounds, okay? These pollutants and these toxins weren't discovered until about 1985, and then the camp was designated actually a hazardous waste site in 1989. So you can imagine over this time frame of 40 plus years, they're estimating somewhere about 1 million people, and that's just not Marines. That's Marines stationed there, that's family members, that's people that were on the site in a non-military capacity, whether food service, construction, otherwise, okay? All these people were exposed. And starting in the 70s and 80s, people came to realize that there were significant consequences of the exposure that they had while living at the space. Cancerous conditions started becoming more prevalent, birth defects, and we'll go through all the kind of medical issues that resulted in a little bit. But this kind of picked up steam, and all of a sudden, we had some litigation going on in the 90s and 2000s, filed by attorneys to try to receive compensation and damages for these veterans. Problem was, and the problem generally was suing the United States government and the military, and challenge for lawyers is that there's something called immunity. So in essence, you can't just sue the government, okay? The government, in its power, and the military, that's power, has certain protections under the law so that you can't go to court and then seek money damages in the same way that you can against a negligent corporation. All right, so if anyone's familiar with the movie Aaron Brockovich, I kind of call this as close as I can find to an Aaron Brockovich type case. And Aaron Brockovich, whoever is familiar with Julia Roberts, the plot of that movie was a factual scenario in the late 80s. There was a Pacific Gas and Electric, PG&E, same kind of scenario. They were polluting the local water source for a town in California with similar chemicals, including TCE, PCE, and chromium, things of that nature. And over time, they did that in the 60s, 70s. Get birth defects, cancers, early deaths, things like that were starting to pop up. Lawsuits were brought in the 90s against Pacific Gas and Electricity, PG&E. And those lawsuits, you could sue for damages, and there's no immunity for a private corporation. Now, that lawsuit took years and years. There's a lot of challenges involved. The government, you can't do that to. And so lawsuits were brought in the 2000s and often dismissed due to various legal hurdles, whether it be the Federal Tort Claims Act immunities, local state immunities in North Carolina where the base is located, VA immunities for veterans, things of that nature, really were hurdles to preventing these individuals that were damaged as a result of living at this base from getting compensation financially.
So,
the US government
Jerry,
did,
I'm sorry. I'm sorry.
John, yeah.
No, I'm sorry. I'm sorry to interrupt, but given that, this new piece of legislation, and what's, transpired in the past and everything else, can you just talk a little bit about how, the Camp Lejeune Justice Act, really sort of what the implications are for these people? Because, what we've sort of come to learn now is that the government, unfortunately, really tried to bury the impact of this contamination for decades. And what we're learning now is that the water was in fact so polluted that, by some measures, it was 250 to 3,400 times the established safety standards set by the government. But when we have the Camp Lejeune Justice Act, that actually was just signed into law by President Biden, I guess really what does that act do for these people, for this, huge amount of people who've been impacted over the past, 40 years? Because, in the past, and again, we're not to sort of get too much off tangent, but in the past, you've got your, if you've been harmed, whether by a defective drug, medical device, contaminated water, you basically have a strict time frame to bring a case. Now, can you just talk a little bit about how this Camp Lejeune Justice Act differs from your traditional mass tort, if you would?
Yeah, absolutely. So the one interesting, back to my Aaron Brockovich scenario, the Camp Lejeune Justice Act, what's really unique about it is that the government, in essence, has admitted that they were negligent for this 40-year period, and they knowingly contaminated the water supply, the air supply, and hurt this group of people, the number of which is estimated to be anywhere from 750,000 to about 1 million people, okay, over this time span. Now, those people that were previously trying to file claims, there were some remedies that they could seek through the VA, Veterans Administration. There were certain disability benefits, a couple of thousand a month. There were certain pockets of money set aside in the past, over the last about 5-10 years under the Obama administration, to get some compensation for people that can prove that they were sickened, families are sickened by this water. The Camp Lejeune Justice Act is unique because it lays out specific criteria and sets aside a pot of money by the U.S. government, numbered somewhere in the billions. We don't even know exactly how much. It isn't a set-aside number, but right now it's not capped, okay? And it applies to all individuals, anybody exposed to contaminated water for at least 30 days, and that's not consecutively. They had to arrive August 1st, leave August 30th. That is a 30-day aggregate period for anybody that was at the camp for a week, then a week a year later, and then a week maybe, a year after that, et cetera. So as long as you're there for 30 days, and it covers exposure between August 1st, 1953 and December 31st, 1987. So if you fall into this category, and we'll go through the kind of illnesses and diseases and cancers and conditions that qualify, then you may file a claim with an attorney, all right? And under this act, the government cannot assert any immunity, and that's what's really, really critical here. So unlike what I talked about earlier, the government cannot say, well, you can't sue us because we're the government. They will admit that we were at fault. We will put a pot of money aside. We will evaluate your case. And if you meet the criteria and if your lawyers assert and prove up the damages, then we will award you a lump sum of compensation. It's not going to be a couple of thousand a month for a disability benefit. You can still continue to have that per the VA and other acts in the past relating to contamination and sickness at this campsite. But this is a lump sum separate settlement as compensation. So the government cannot deny. The government has no immunity, okay? And there's a couple other provisions, but that's mostly the important part. So there's about a 2-year window starting from about a week ago, right? From early August 2022 until 2024, that anybody within this category, and we'll go through the illnesses in a little bit, file a claim. All right, all cases need to be brought and filed in the Eastern District of North Carolina. And John, you and I can go into that in a little bit, but that means you need an attorney that's licensed to practice in federal court and can file these lawsuits in the Eastern District of North Carolina. And then we'll see. It's unique in the sense that there's no cap. There's no threat of bankruptcy. Okay, the government's going to set aside money. A corporation that poisons waters can say we don't have the funds to pay 1 million people who we've sickened. All right, that's not going to apply to the United States government, and that's what really makes this a unique act.
Yeah. I mean, kudos to the government for and really the Biden administration for stepping up, because for decades this sort of issue has been really tried to be buried under the covers, and what we've seen now is really just a massive number of veterans and their families and other contractors who've really been vocal in the past about their illness and about the contamination, and for unfortunately they've just been it's fallen on deaf ears and just been ignored. So we've got this Lejeune Justice Act. People can certainly, it's out there. They can take advantage of it by contacting an attorney. But what I want to talk to you now a little bit about is, I guess, as someone who's sort of on the front lines of this litigation, when you are talking to families, when you're talking to individuals, what are the symptoms that a lot of these people are coming forward with? When you're talking to someone, on the phone or on Zoom or whatever, what are the main types of complications and illnesses that you're seeing?
Absolutely. So again, the criteria being that you had to have 30 cumulative days from August 53 to December 87, and you weren't dishonorably discharged. If you are an adult that continues to have following presumptive conditions kind of were listed. So we're talking about majority cancers and neurological conditions, as well as in utero. So the criteria for the presumptive conditions were adult leukemia, aplastic anemia, and other myelodyaplastic syndromes, bladder cancer, kidney cancer, liver cancer, multiple myeloma, non-Hodgkin's lymphoma, and even Parkinson's disease. So we're talking about cancers and neurological disorders. What do you have to do required to support that for documentation? Again, prove that you were at the camp for at least 30 days. So that would be any military records, okay? And then any medical records showing you have some of those illnesses. Now, those illnesses are going to be expanded, all right? Because what this Camp Lejeune Act did is kind of take the categories that I just listed with these cancers, neurological conditions and the like, and expanded them. And also, significantly, this act applies not just to active members who were present there and ill, but also it's in utero. So in other words, expecting mothers who were at the base, lived at the base, or any women that had complications with pregnancy and their offspring had neurological conditions, cancers, maybe there were miscarriages, fatalities at birth, et cetera. All those are also covered potentially within this act.
So the Justice Act, another, thing that makes this unique is that you typically, you've got this, most cases are governed by, a statute of limitations. And so, especially if you've lost a loved one in an incident, you have a set time to file a case. And obviously you do, the clock is running right now, but for someone who may have lost a loved one who may have succumbed to some of these diseases that you mentioned, is a person like that, are they eligible to pursue a claim?
Yeah, pretty much anybody that was on the base, anyone that was parents. So, for example, if your parent was at the base and you believe had any of these diseases, passed away, and these are expanded, okay, and that was brain cancer, breast cancer, cardiac, cervical cancer, esophageal cancer, female infertility issues, immune disorders, kidneys, livers, we talked about that, even lung cancer, myelomas, neurological disorders, non-Hodgkin's, even prostate cancers, renal toxicity, spinal bifida, anything that, pretty much anything and everything that is out of the ordinary that is on this list should be investigated by a competent attorney. Now, there's going to be some questions as to family history, things of that nature. There's going to be medical causation that needs to be proved up. But if you're on the base, meet the criteria, and have any of these host of conditions, or had them, had surgery, recovered, followed up, et cetera. Or if your family members passed away who were stationed at the base, and you can prove up that they were there, that they had these conditions and died as a result, okay? Or if you could prove up through medical records that you had miscarriages, et cetera. All that is potentially compensable and needs to be reviewed, it needs to be filed, and an attorney and experts will obviously have to do a lot of the work to make sure that the compensation is obtained. But the categories available here are very vast, and that's what makes this also a very unique mass tort. As you know, John, sometimes in drug manufacturing cases, Roundup and other kind of toxic chemical exposure from private companies, the cancers themselves are very limited and specific. So, for example, okay, our drug caused specific breast cancer. It's the only cancer our drug caused. Or our chemical spray caused non-Hodgkin's lymphoma, and that's the only thing it caused. So if you have liver cancer or kidney cancer, that's not us, right? That's often the case in multi-district litigation, MDL, and class action work. Not in this situation, and that's what makes this unique.
So, I guess if someone's watching this, they're probably, getting bombarded with, commercials on television, hey, if you've been, injured at Camp Lejeune, contact our law firm for a consultation, and they're starting to think, what, I think I may have a claim, my father, my mother, maybe yourself suffered one of these illnesses that you've mentioned. I guess sort of what is the sort of the first step that someone needs to take or can take to sort of join this litigation and really preserve their rights? Because as you mentioned earlier, there is a 2-year time frame to file a lawsuit. And a lot of times people are, they're hesitant. They sometimes try to forget what's occurred in the past. But I guess in your, legal expertise, what would you suggest someone do if they think they may have a potential case?
Absolutely. Well, given the wide area provided by the government and the types of conditions and the types of potential, 30-day rule requirement, it opens us up to a host of possibilities. So if you have had a family member, your parents, for example, that passed away from a cancer, an autoimmune disorder, or the like, and they were stationed there in the 1960s, you should contact an attorney like John and myself to work and discuss the possible case. If you were stationed and you suffered, any of these autoimmune diseases, cancers, you had surgery, you survived, or you're in remission, but you had to go through chemotherapy, you should absolutely contact an attorney like John and myself. If you had in utero complications, so if you were at the base and your children had autoimmune disorders, were born with neurological defects, etc., you contact an attorney. Pretty much anybody, whether mostly military, but even if you're not military and you had family members stationed from contractors, the military doesn't just work within its own. They hire outside contractors to build things, to clean things, to cook things, to provide entertainment, etc. If anybody who's on that base for 30 or more days used that water, cooked with that water, brushed their teeth and washed their face with that water, was exposed to that air, they should contact an attorney. What firms like ours do, John, as you know, is it takes an army, for lack of a better term, to manage the kind of cases these are. So we're dealing with a lot of people, right? And not a lot of specific information. So we're talking about hospitalizations in the 60s, 70s, 80s, or 90s in various parts of the country. So you need attorneys that are able to track down medical records and obtain the kind of evidentiary proof that the government demands. You as the person that's contacting us, we need some basic information from you, military records, proof that the person was there, proof that you were there during the specific time period for 30 days or more. And then it's on us as the attorneys to gather the medical records and make sure that you qualify and fit into the criteria, file your lawsuit in the Eastern District of North Carolina within the 2-year statute limitations to make sure that you're in the pot of money that's available, and then litigate and work with the government in whatever means that's going to be. We're still unsure exactly how, to get a proper amount of compensation.
So, basically when someone, hires an attorney, they hire your office or whatever, one of the benefits of it is that basically, they hand off that responsibility of getting all these medical records, getting all the medical bills. All that responsibility is basically off their shoulders. They can focus on their medical care if they need to. They can focus on their family, themselves, and basically the attorney handles everything. Is that correct?
Absolutely. So we take a contingency fee agreement, so there's no cost. So basically, if there's a recovery, the attorneys will take our percentage of a fee. And if you can prove to us, very simply, through a basic record of some sort, that you, or the person you're calling on behalf, your parent, your child, whatever, was at the military base in a military role or otherwise for this 30-day period, not all at once, could be aggregate over those years, then, and you have one of these conditions, then we will obtain the medical records, the medical bills, gather everything, sort everything, put it into litigation, file it appropriately, keep track of everything, and see how the government handles this after the 2-year expires in August of 2024. The critical thing here is that there's more or less strict liability. It's a legal term that we lawyers like to use. And what I mean by that is if you fit into these parameters and the medical records support it, and that's our job, is to get those records, support that, place you into the pot of, in the pool of individuals, and then fight for the highest number. The government's not going to say, well, we're not giving you anything. If you qualify, there will be financial compensation. The amount is yet to be determined. That's going to depend on the fund that's set aside by the government. And I imagine, John, that's probably your next inquiry of me is, what do you think the amounts are going to be?
Absolutely. You are reading my mind, Jerry Bekkerman. The next thing, next thing I want to talk to you about is, I'm online. I'm looking at a lot of these, military bulletin boards, online discussion about the Camp Lejeune litigation. And, one of the things that frequently comes up, just like any other type of personal injury mass tort case is, okay, I've been harmed. Now, really, what is the process? What am I looking at in terms of getting compensation? So, can you talk a little bit about the compensation that, will likely be available for a victim of Camp Lejeune? A lot of times, they're, especially if people maybe they have disability or something, they're looking for some type of a formula almost for what their type of case may be worth. And, I think you'd agree that there's really part of really being a trial attorney is trying to, maximize the damages on these cases. There's a lot of attorneys out there. Obviously there's some attorneys who really concentrate in trial work, as I know you do and your office does. But in terms of the damages here, what type of damages can someone be compensated for?
Great question, and that range is wide. Obviously, depends on the individual and the harm suffered. So, if you, a loved one, a parent, or you individually has been suffering from one of these cancers, had kidney cancer with multiple surgeries that's affected your life, you've been on chemotherapy on and off, in remission and back, that's a significant case. If you've lost children in utero, if your child was born with birth defects as a result of the contamination and the toxins passed in utero, that's going to be a significant compensation. And that's probably going to differ than, for example, that somebody that may have just had, some autoimmune disorder, or maybe a cancer that was a stage 1 or 2 that didn't require surgery and didn't require chemotherapy or something of that sort. So there's going to be a range. How much are the numbers going to be is an unknown. We have some examples. There's a $350 million fund that was set aside by the Department of Veteran Affairs a few years back. Obviously, a grossly inappropriate number that was, kind of meant to distribute among people that qualify for some of these presumptive conditions, not as vast as this Camp Lejeune Act. And there are some disability benefit awards that we can at least look to. A veteran that worked in Camp Lejeune in the 80s, diagnosed with bladder cancer, was a $1,100,000 award or settlement that the government, pursuant to the fund and the Veterans Administration, agreed to him with. There was a different one. A service member harmed by contaminated water received $100,000 in benefits from the VA, and this was kidney cancer. All right, so the range could be anywhere from $100,000, $1 million, and up. And it's really hard to kind of put a hard number on this. What we do know is that there's not going to be a set amount of a fund. Right now, as per the law signed by President Biden, the amount that's going to be put in will be in the billions, plural, without a number in front of it. A lot's going to depend on how many people submit their claims within the 2-year statute, which is why it's very important to get a lawyer and to get the process rolling. There's a lot of paperwork, and we have to do on our end a lot of record collection, investigation, and the like. Once the amount of people, whether it's 700,000, a million, or 2 million, is determined, and all the criteria are met, I assume the government will get together with the attorneys. X amount of funding will be set aside.
Interesting. So, I guess the bottom line is, don't assume any, as a victim, never assume that, you're just going to get the compensation you're entitled to by sitting idle. It's really incumbent upon you to really take action and, hire an attorney, to get the compensation that you deserve. If you're sitting back and saying, oh, you know what, the government's going to take care of me, this is really not the time to take that approach, correct?
Absolutely not. If you don't get into this 2-year window, then you are not going to receive anything. So the worst thing you could do is sit this out on the sidelines. And again, because this is such a unique admission by the government, I've never seen this, okay, to this extent, to set aside this much money, which is the right thing to do, considering the immense harm to members of our military community that was inflicted. Set aside a fund with an infinite number on it, okay, and give this much of a window, 2 years, is really an incredible opportunity. It's a great and the right thing that the government is doing, but it's incumbent upon people who believe that they may have a case to contact a lawyer. The worst thing you can do is sit this one out. The easiest thing is pick up the phone, call you, John, call our office, go through our intake process, answer 10, 15 minutes of questions, look at some documents or pull up some military records, take a few minor steps, and then let it go. All right. And then in 2 years, a lot more information is going to come out on what the case is worth, how much your family will receive, et cetera.
So, Jerry, obviously we're really early phase of this litigation. There's going to be plenty of questions. There's going to be plenty of forthcoming information about these cases, but I really want to thank you for talking with me today. And, hopefully you can come back and we can talk about, as this information unfolds, we can talk about the different options available and what we're learning. But thank you so much. And, hopefully you'll come back and talk with me again, but we'll be in touch. And if anyone has any, questions or anything, they're obviously, I'll put your contact information in the video, in the podcast, and they can go from there. But we will see. This is certainly a really groundbreaking litigation that we're entering into right now.
Yeah, absolutely. And as updates develop, we'll probably have another one of these podcasts, give an update on any new amendments, anything new signed. This seems to be an evolving area, but it is an absolutely a wonderful opportunity for these families to get compensation if they were harmed. So thank you for having me on, and we'll talk to you again soon.
Thank you.